A very good morning to everyone attending from India and from other parts of the world. I, Chirag Balyan, on behalf of Indian Review of International Arbitration, published by Center for Arbitration and Research, Maharashtra National Law University, Mumbai, extends you a warm welcome to the fourth distinguished lecture on international arbitration by none other than Professor Jeffrey Waincymer. We also have the distinguished presence of Dr. Akhil Prasad. Dear friends, we started distinguished lecture series in 2021. The idea was to bring scholars of international repute from around the world to this platform to share their ideas on international arbitration. The vision was, if India is to become a hub of international arbitration, first of all, a strong scholarly debate must happen in India. And for that to happen, we started with two initiatives. One was starting a journal, though there are many journals around the world. But coming from a South Asian country, putting a perspective of the developing countries was one of the major idea. And second, to support the journal was to have an eminent expert like Professor Jeffrey Waincymer, who would deliver a lecture. As I mentioned, this is the fourth lecture. The first one was given by Professor Julian Chase. Then we had Mr. Kevin Kim from Korea. Then we have Ms. Shan Bao. And then after a lot of correspondence, we could, with some difficulty, get the time of Professor Waincymer. All of you know he's a very busy arbitrator and mediator, and it's very kind of him that he accepted our invitation. I was telling to him in our informal interaction that his work on procedure in international arbitration, procedure and evidence in international arbitration, published by Wolters Kluwer. In our class on international arbitration, we read it para by para. We had extensive discussions based on his book on how a common law country will draft notice to arbitrate and how a civil law country will draft a notice to arbitrate. What kind of thinking will go in the statement of claim, in the evidentiary issues, in counterclaim and set-off, especially counterclaim and set-off part. If you see in his book, it's very impressive, very complicated idea, summed it up in a very, very nice way. So that was the idea, that the work, the person of whose work we are referring day in and day out, we should invite the legend himself. So we invited Professor Waincymer, and he agreed to speak on identifying intent to arbitrate and arbitral validity. Why have so many common law courts tied themselves into unnecessary and unresolved notes when aiming to discern the law applicable to the arbitration agreement? One of the most important issue, lot of decisions are coming from United Kingdom, one reversing the other, majority speaking different language than the minority, Singapore, Hong Kong, India, from where we see all common law courts are coming up with different approaches, and then there are civil law countries. And I'm very sure Professor Waincymer is going to highlight his ideas and thoughts on this topic. With this small introduction about the lecture series and today's session, now I pass on to Dr. Akhil Prasad to give the welcome address.
Thank you, Professor Balyan. This has been indeed an honor for me, to be here at this very important lecture series. And thanks for including me as a part of this lecture series. And I warmly welcome Professor Waincymer also, to share his views on this very important subject, which is so relevant because a lot of disputes get delayed because for the simple reason which rule of law should be followed, what should be the forum of arbitration. And before, the actual arbitration proceedings commence, often the disputes get, the resolution process gets delayed because of lack of clarity on these subjects. So I definitely, would like to hear Professor Waincymer's view on this. But before we proceed with Professor Waincymer, in my own view, what I believe is that Professor Balian, as you mentioned, that India needs to become an international hub for arbitration. I think what we have seen in the last few decades is a very phenomenal development in terms of pro-arbitration process that the courts of this country have adopted. We have seen so many Supreme Court judgments which have upheld the finality of arbitration awards. We have seen that there has been a lot of transformation and change to the Indian law relating to arbitration. And I think we are poised in the same direction that India should become a hub for international arbitration. And the recent Supreme Court judgments, which also now allow international arbitration between two Indian parties to be done, anywhere in the world, is also a very welcome step, because it used to be a public policy issue earlier. And that hurdle also perhaps has been taken away by the Supreme Court of India, which is a welcome step. But from my own point of view, I must confess that arbitration, in my about 28 years of being a general counsel, local arbitration, I have always preferred to be held in India. Whenever we write contracts, there has been a lot of push from the companies that we work for, because international companies want to either do it in Singapore or they want to do it in London. But my own preference has been that if we have to resolve a dispute in India, it is better we do it in India. And that is the approach we have taken in our international contracts, as well as in the domestic agreements. One thing also I would like to add that, a company like ours, which is Boeing, we supply planes and defense equipment to a lot of customers in India. So some of the contracts have, for example, commercial plane contract will have an international arbitration, but defense contracts, whenever they are signed, they will always have, from a defense policy point of view, that it should be subject to Indian law and Indian arbitration. So whenever a defense manufacturer would like to sell products to Indian government or to the Indian armed forces, they will always want it to, that arbitration should be subject to Indian law and under the Indian arbitration rules. Another thing quickly, Professor Balian, I would like to mention is that we have institutions of eminence like the MNLUs, and Maharashtra MNLU is one such university of excellence. My own personal belief is that although we have a lot of arbitration centers in India, but with the depth of knowledge, with the depth of infrastructure that our universities, law universities in India possess, we should definitely give it a very serious thought that we should also develop arbitration centers in the national law universities or other leading universities in India. Because of the depth, because of the spread these universities have in India, I think tying up with professionals, with international professionals like Professor Waincymer and with other international associations, I think we will be able to develop a great international ecosystem with these national law universities in India. And so that's my initial thoughts, Professor Balian. Over to you. And I wish, this lecture series to be a grand success. And we are all ears for Professor Waincymer to, spread his words of wisdom.
Thank you. Thank you, Dr. Akhil. And before I pass on to Professor Waincymer, he does not need an introduction, but still allow me to read his bio. He is an independent arbitrator and mediator. He consults generally in the field of international trade and investment, custom laws, and trade remedies. He's an adjunct professor of law at NUS. He's on the panels of Hong Kong Center, Singapore Center, Asian Institute of Arbitration Center, ICDR. He's an honorary fellow of CR. He has previously worked as an Australian government nominee, as a panelist for the WTO and ICSID. He has conducted pro bono legal capacity building in a range of developing countries and for a range of aid agencies. Some of his books are Procedure and Evidence in International Arbitration, published by Kluwer, WTO Litigation, published by Cameron May, Australian Income Tax, published by Butterworth, joint author of a guide to the new ancestral arbitration rule, published by Cambridge, a practical guide to international commercial arbitration, published by Oceana. So if you look at the kind of publications he has done, he's an arbitrator who knows numbers, who understands taxation. So who could be, I haven't seen many arbitrators who understand numbers as it is, evident from his profile as Professor Waincymer does. And arbitration is in fact about number. Professor Waincymer in his books talks about arbitration is about facts. It's 70% facts and very less about law. And within facts also, it's more about number, how much money we are entitled to. And I'm sure with his taxation knowledge and the other kind of experience he must be doing the best service he can do to the society and the arbitration community. We welcome you, sir, for the 4th lecture. Please do the honor.
Thank you very, very much to you both for the invitation and the overly kind words. It's a pleasure and a privilege to be with you all. It is always very difficult to talk on a topic that I think is controversial for this reason. This is the first time in my life I have ever thought all of the courts are wrong and all of the commentators are wrong. And those who have read my work, as the professor has and alluded to, my interests are never to criticize judges or to try and say my ideas are better than yours. I try and be very practical, commercial, client-focused in terms of really the role of an arbitrator to service the parties who want from that arbitrator an efficient, commercially sensible resolution to their dispute. But on this particular topic that I'm speaking to today, I am seeing well-meaning courts all around the world who are genuinely trying to support arbitration, actually making it worse because they are worrying themselves about trying to find exactly what is the law of the arbitration agreement. Now, some of you will have read the leading cases that the professor talked about. Some of you will not. And it's my job to make this interesting and stimulating for everybody. And I'm not going to be reading out or showing you great passages from judgments, but I aim to try and give you a flavor for what those cases were about and what they decided and why I think that's the completely wrong way to go about it if a court is truly aiming to be as supportive as the introductory speaker rightly alluded to, which is the trend in India and around the world, but worrying so much about this supposedly important question of the law applicable is, to me, a retrograde step. So let me put it into a practical perspective. Whether you have read the cases or not, imagine that you are an arbitrator sitting in London. The parties have agreed to London as the seat of arbitration. And the contract says it is subject to Brazilian law. And one of the barristers comes to your court and says, I'm not absolutely sure, but I think under Brazilian law, an arbitration agreement is not good enough. you need a separate agreement after the dispute for there to be arbitration. You're a London-seated arbitrator. You know that there is no such requirement in the English Arbitration Act. If you are a Mumbai-seated arbitrator, you would know that there's no such requirement in Indian arbitration law. What's your gut reaction? Do you think you have jurisdiction, or do you think you don't because what somebody told you Brazilian law might have? Let me pose a second hypothetical. You're still an arbitrator in London. The parties have clearly chosen London as the seat. It's not clear whether they have chosen a law of the contract, but if they have, it is Russian law. And one of the party, and the contract is for a subcontractor who did some building works in Russia. A fire happened and they were sued for causing the fire. And there are claims both in contract law and in tort, the tort of negligence. You breach your contract because your works weren't good enough, and you're also liable in negligence. One party starts a court case in Moscow, not an arbitration. And when they're asked why, they bring along a Russian expert who says, if Russian law applied to the arbitration agreement, Russian interpretation of the words in connection with this contract, all disputes in connection with this contract go to arbitration. The Russian expert says that doesn't cover tort claims. So you are sitting there as the arbitrator in London. Do you honestly think that the parties intended the same facts to be rehearsed in an arbitration for the contract claim and rehearsed in a Moscow court for the tort claim? Now, I don't think many people at all sitting as an arbitrator in London would accept that. And these two fact situations are the two leading English cases. The first scenario was Sol America, where the court worried about whether Brazilian law applied to the arbitration agreement in a clearly London-seated arbitration. And the second fact scenario was Enka, where the court also worried whether Russian law applied to the arbitration agreement and maybe meant that a tort claim was not in connection with the contract, the very words drafted into the contract. Now, my view, hopefully as the professor introduced me, the practical arbitrator, the one who cares about facts, would say that most arbitrators would actually say, I think there is an agreement to arbitrate. And if that particular arbitrator thought of the words of the Indian Supreme Court in Enacon and listened to what the court said there, which is the courts have to adopt a pragmatic approach and not a pedantic or technical approach while interpreting or construing an arbitration agreement or arbitration clause. In such a case, the court ought to adopt the attitude of a reasonable business person, having business common sense, as well as being equipped with the knowledge that may be peculiar to the business venture. Now, every common law country, as you know, when its highest court speaks of contract interpretation, now speaks in that language. It now speaks about don't be pedantic, don't play semantic and syntactical games, interpret commercial contracts for the way sensible business people would want them to be interpreted. But this line of case law that says you must find a law of the arbitration agreement and then do whatever it says on validity, on scope, on forgery, on agency, on non-signatories, that runs the risk that all of these courts will go backwards when they mean to go forwards. So what do? They all say, we need certainty. We can't have a system where some people think the law of the contract applies to the arbitration agreement, and some people think the law of the seat applies to the arbitration agreement, where I say, apply, you may need to do that. You may need to look for an applicable law, but if you applied the same commercial logic as the Indian Supreme Court in Enacon, you just try and do what the parties really intended. It's not always easy. It's often contested, but you're trying to give effect to the true intent of the parties. And I don't think anybody with that mindset would think that people who chose London as a seat in Sul America would care about what Brazilian arbitration law said. You're not arbitrating in Brazil, you're arbitrating in London. And an arbitration agreement in a contract is valid. And that's all there is to it. And similarly in Inca, you would say, I'm not going to interpret these words in connection with so narrowly that you can't have the tort claim decided at the very same time as the contract claim by the same facts, by the same witnesses, by the same adjudicator. So that's the background. That's me trying to say to the listeners, couldn't we resolve these things practically and commercially? And why is it that we need these particular applicable law? Now, I say that the courts are doing three main things wrong, but probably about five. The first thing they're doing wrong is asking the wrong question. What is the law of the arbitration agreement? And I'll try and explain why that's not the question. The second thing that they do is to fail to consider how that matters for different types of applications. And I'm only criticizing preliminary courts. I'm not trying to say anything about annulment courts or enforcement courts, because for them it's easy. The New York Convention, the Indian Arbitration Act tells you exactly what conflicts rule to apply. You can only annul by the law that the parties have applied to their arbitration agreement, and if they have not, the law of the seat. It's very clear, it's very straightforward, there is no contention whatever. I am only speaking to the preliminary courts. What kind of courts? A court asked to stay litigation in favor of arbitration under Article 8. A court asks for an anti-suit injunction, again to support arbitration. A court asks for an anti-arbitration injunction to support a court. A court asked, which is very common in India, unfortunately, asked to appoint an arbitrator, where I understand there's a tremendous backlog, and the Supreme Court published an order demanding that the backlog be cleared in a 6-month period, and that's the delay that the kind introducer mentioned that is something that needs to improve as well. And the final two would be applications for leave to serve proceedings out of the jurisdiction, and finally applications for interim measures. And my argument is that if a court knows that it's only a preliminary court and asks the right question, the answer to that question, it has to think about who's got the burden in each kind of preliminary application, and what's the standard of proof, and by what evidence are you going to make a decision, and how deferential should you be to the arbitral process. And the final thing I'll take you to is the particular challenge being posed to either validity or scope. And my point again is when you look at the leading cases, they seem to say that once you know the law of the arbitration agreement, you can find the answer to anything. And the only worrying case in India is a very old one that many of you would know of, which is the National Thermal Power case, which back in 1992 said the law of the contract will almost always apply to the arbitration clause. It did not discuss separability as later cases did. It used that to find dual supervisory jurisdiction for Indian courts and foreign courts, which the current Supreme Court, I'm sure, would not allow anymore. But if its statement that the law of the contract applies to the arbitration agreement, that court said that will give you the answer to validity, effect, interpretation, scope, voidability, illegality, and whether it applies to third parties. For every challenging issue, that court said, once you got the law of the arbitration agreement, you have your answer. That is not what the Indian Supreme Court is doing when it deals with group of companies and application to non-signatories. It is trying, in leading judgments, moving further than most other common law jurisdictions, it's trying to develop a commercial thesis about when and why in a complex corporate group you really should be able to bring non-signatories into arbitration. That's very contentious. I'm not trying to profess a particular view either way, but I am saying that what the court is doing in India, which is thinking about it directly and having a sensible set of principles for it, is the correct way to go. Slavishly saying, I must find a law of the arbitration agreement, and I must then take it and use its law of agency or assignment or subrogation to automatically extend my arbitration agreement, to me, that goes far away from arbitral consent. So before throwing into the critique, I need, for those who are not aware of the cases, to, in about 1 minute, tell you what the cases decided. And the cases basically said, which we would all agree with, if you think you need a law of the arbitration agreement, we are bound as adjudicators by any agreement of the parties. If the parties want to say what law applies, I, as an arbitrator, must respect that. That is a centerpiece of arbitration anywhere in the world. They also say rightly that agreement can be express or it can be implied. Everybody would agree with that. The next thing they say, understandably, where you have a choice of law clause in your contract, this contract is governed by Indian law, for example, the cases say that does not necessarily cover the arbitration agreement because of separability. Separability means you can treat the arbitration clause separately, and it doesn't necessarily apply a general clause. But then they go on to say, even if it does not expressly cover that, it is evidence of an implied intent that that law would apply, with two exceptions. It won't apply, the law of the contract won't apply, if something in the law of the seat says it should apply instead, or if the law of the contract would make the arbitration agreement invalid and the law of the seat would not. So a pro-arbitration validation principle is, we will use the law of the seat one way or another, either express or implied, but we won't do that if that's going to undermine the agreement. if the law of the seat would support it, in the same way that we learn the Latin maxim ut res magis, that parties are presumed to want a law to be valid rather than invalid, which is a classical piece of interpretation all around the world. The next thing the cases say is, if you cannot find express or implied agreement as to the applicable law, you must use domestic conflicts of law rules, which in the common law world is a closest connection test. They never ask why, they never debate it. All of the barristers march into the room and say, of course you have to. You're a common law court. That's your private international law. That's what you have to do. So they say, okay, I've got a separable arbitration clause. I've got to find the closest connection to that clause by itself. Of course it's the seat. So they basically say it's the law of the contract if you have one, unless it makes it invalid. And if that makes it invalid, it will be the law of the seat. And there you've got your answer, and that's what we need for certainty. So what's wrong with that logic? And why do I hope when the Indian Supreme Court, who hasn't gone down this route, but has someone throwing the English Supreme Court clear decisions now accepted in Singapore as well, will Indian Supreme Court be overwhelmed, or will they be able to say, you've got it wrong, please do something very, very different? Why do I think they've got it wrong? I started by saying they're asking the wrong question. What is the right question? The right question is not, if you're only a preliminary court, you're only a court dealing with a preliminary application, you've got at most affidavit evidence. You're not hearing witnesses. You're not going through the negotiating evidence. You're not considering the parole evidence rule, whether that applies and what evidence you will hear. You're just a quick preliminary application to appoint an arbitrator, which is the main way that this comes up in Indian courts. You shouldn't ask what the law is. You should ask, what could the tribunal do? What could the putative tribunal do? And if you ask that question, you will come up with one of three answers. You will either find no reasonable tribunal could find arbitration jurisdiction, in which case you leave it in the courts and you don't support the arbitration. Or you conclude no reasonable tribunal could do anything other than find valid jurisdiction, in which case you kick it out of the court and you help the arbitration. The third possibility, and the most likely one, is some reasonable tribunals could find jurisdiction and some reasonable tribunals should not find jurisdiction. But it's reasonably open to a tribunal to find valid jurisdiction. And if that's the case, you should do what the Indian Supreme Court in Vidyadrolia said you should do in 2021. And the court said the general rule is that the arbitral tribunal is the preferred first authority to determine and decide all questions of non-arbitrability. Rarely as a demurrer, the court may interfere at the Section 8 or 11 stage when it is manifestly and ex facie certain that the arbitration agreement is non-existent, invalid, or the disputes are non-arbitral. But the court by default would refer the matter when contentions relating to non-arbitrability are plainly arguable, or when consideration in summary proceedings would be insufficient and inconclusive, and when facts are contested. Now, if you're honorably doing that, which every good court says it's doing, it's not doing it if it then says, what is the law of the arbitration agreement? If it's really doing that, it should say, what law could a tribunal apply? Could it apply a law that makes this valid? If so, it's not manifestly invalid, and therefore I can't keep it in the court and I must support the arbitration. So the court should not be looking at what other courts say the law is. The courts, for example, if it's in Mumbai and it's the Mumbai Arbitration Centre, the court should look at Rule 24(1) on applicable law, which says the tribunal shall apply the law designated by the parties. Failing such designation by the parties, the tribunal shall apply the law and or rules of law which it determines to be appropriate. So if I was a judge asked to appoint an arbitrator for a Mumbai arbitration, when one of the parties says this is an invalid arbitration for various reasons, I should not be saying the law of the arbitration agreement is the law of the contract or the law of the seat, unless the parties have selected it. If they've selected it, fine. If they haven't selected it, I should say, how much of a discretion does the tribunal have? A very broad one. If the tribunal could find validity under either the law of the seat or the law of the contract, then it could be valid. I must do what the Supreme Court in Vidyadrolya recommended, send it to arbitration. The structure of the New York Convention, the model law, the Indian Arbitration Act is let a tribunal go first unless the court knows it would be a waste of time. If it's clear on its face that this is not an arbitration, then you can deal with it. And at least one Indian court was able to do that just by looking at two clauses. It looked at two clauses. It saw the arbitration could not bring these two contracts together. It was able to do that. That's fine. But if there's any evidence relevant or there's any dispute to be determined, why is a preliminary interlocutory judge with no witnesses and no real evidence and no time to have a full hearing and no interest in affording due process to the parties to go away and present arguments and make submissions and cross-examine witnesses, why are you making a decision? That is not the structure of what the system should be. That's not the intent of the Law Commission in India. That's not the intent of all the changes in the legislation. That's not the intent of these more recent Supreme Court decisions. But it becomes inexorably a retrograde step if the court thinks I have to tell you what is the law of the arbitration agreement. That is then determinative in all things. The next thing to understand, and this is relevant to people who've read more about it or who are more familiar with the New York Convention, some people argue in all of these cases that you really have to make it the law of the seat because that's the default in Article 5(1)(a) when you come to block enforcement, and that's the separate rule with annulment. And they say, how can you have a different law at each stage? How can you have a law of the contract at one stage and the law of the seat later on when you're annulling? And I didn't listen to the lecture, but I understand Lord Hoffman in the last 2 or 3 weeks gave the Gaillard lecture in Paris, and I think argued against Enker in favor of the law of the seat. And Albert Jan Vandenberg's book can be referred to for those purposes. And the US restatement on the law of arbitration tries to argue that for that reason. I do not argue that. Why? Because it's not the same question. If you follow my recommendation, I am not asking anyone to say what the law is. I am asking the court to say, what could it be? If the Mumbai arbitrator has the broad discretion in 24(1), she or he could apply the law of the seat to be consistent with the New York Convention. But they would not be wrong if they applied the law of the contract. They would not be wrong if they didn't worry about a law of the contract and just use the intent-based logic from Enacon and said, I don't need a law. Any law that I apply will make me look at what commercially minded business people will do, and I will try and decide, was there really intent for the parties to arbitrate this dispute or not? So I don't see any need to have this consistency if you understand what the law is at the right time. What the question is at the right time. The second fault that I find with the cases is how they find intent. They're perfectly right to say if there's an express agreement, you're bound by it. They're perfectly right to say if there's an implied agreement, you are bound by it. They are perfectly right to say the doctrine of separability means that maybe a general clause doesn't apply. But if you write a general clause and all you say is this contract is governed by, that is a bad clause. That is bad drafting. Why? Because if you know about the doctrine of separability and you know that that clause might not apply to the arbitration agreement, all you needed to do was add 4 words and no one would be in doubt. All you needed to do was write your choice of law clause to say this contract, including the arbitration clause, is governed by. Or if you didn't want that, you'd say this contract, excluding the arbitration clause, is governed by. The absence of those 4 words makes the drafting bad, and it makes a nonsense of courts that say we need to decide this for commercial certainty. We need to tell you what the law is. There is no right answer to bad drafting. The only answer to bad drafting is do better next time. But if you've got bad drafting, you've got to have a decision. You've got to decide, in my view, what's the real intent of the parties. And in that circumstance, you go back to Enacon. What did the parties mean in these circumstances? And some arbitrators would call evidence. Some arbitrator, even in the common law, even with a parole evidence rule, we now know that you can have parole evidence when there's ambiguity. And if it's bad drafting, there's ambiguity. And you know that common law world has restricted the scope of the parole evidence rule over the years in any event. So to think you need a theory because of what you describe as bad drafting is, to me, inappropriate. And it is all ignored what Lord Neuberger said in Sol America, where he said, and no one keeps repeating this, and they should in every case, once it is accepted that the issue is a matter of contractual interpretation, it may be that it is inevitable that the answer must depend on all of the terms of the particular contract when read in the light of the surrounding circumstances and commercial common sense. So Lord Neuberger said just what the Indian Supreme Court said in Enacon, and nobody quotes that anymore, and they all say we've got a grand theory. My next criticism is that the cases run away from express intent when they say, look, we're not sure whether a general choice of law clause applies in the event of separability. That's fine, but you've got to make a decision either way. How will you know whether it does or doesn't without looking for contemporaneous evidence? If the two negotiating parties say, I've never heard of separability, then you could easily, as an arbitrator, say, on plain meaning, that choice of law clause applies to everything. Conversely, if they're both arbitration experts, you might say they know about separability and they might not have intended it to apply. So most of the cases don't bother even making a decision, and nor could they as a preliminary court without hearing evidence. The next thing they do, which makes no practical sense, is they say, well, a general choice of law clause is not evidence of express intent, but it's evidence of implied intent. Now, how can a clause that they just decided is not speaking to the arbitration clause now an implied intent about the arbitration clause? It either talks to that clause or it's not talking to that clause. If it's talking to that clause, you've got an express agreement. If it's not talking to that clause, where did they invent this implied understanding with bad drafting without going to commercial common sense or the extraneous evidence? So why are they doing that? And they're doing it to be nice. They're doing that saying we need certainty, we need a rule, we need a principle, we need to help people here. If you want to help people, give them some lessons on drafting. Teach them how to write contracts better. Don't have legal theories based on contract drafting. The next thing that they do wrong is if they cannot find express or implied intent, they say we must use a closest connection test. And even in the first case, Sul America, that was agreed between counsel. Nobody questioned that. My argument is this: when you are a merits court in India and you are dealing with a foreign element of law, of course you must apply Indian private international law. And if Indian private international law says that an Indian judge in an Indian court dealing with a contract crossing borders without a choice of law clause must look for the law to which it has its closest connection, that is a binding principle of Indian law. But if an Indian court has a person starting litigation in a contract that has a very clear London-seated arbitration clause, why is that Indian judge applying Indian private international law developed for when it's a merits court to what I think is a different question, which is, what could a tribunal do? What laws could a tribunal apply? Is the tribunal bound to use a closest connection test? Absolutely not. It's not written into the Mumbai rules. It's not written into the Indian Arbitration Act. So why are you using your private international law binding on you when you're a merits court for arbitration that is never bound in that way? So again, they're doing things completely inappropriately to get to some rule to say, if I'm using a closest connection test to a separable arbitration agreement, I must pick the law of the sea. No matter what happens, whether it's a good outcome or a bad outcome, that's what I must do. Now, let me take just 5 more minutes just to wrap up the other 2 things I do wish to talk about and leave people with an opportunity for questioning. So I have said courts that know they're only a preliminary court, like Indian courts trying to be supportive of arbitration and letting the arbitrators go first, should focus on what an arbitrator could do. The second thing that they should do is to then bring the answers to those questions into the particular anti-suit principles, or sorry, the preliminary principles. So when the Indian court says rightly, if we're only being asked to appoint an arbitrator, we're not meant to decide if the whole thing is valid or not. If there is an arbitration agreement we can see, it's not our job to say whether it was induced by fraud or any of these things. There's a prima facie arbitration agreement. let the arbitrator do the work. We will go second. If it's an Indian-seated arbitration, we will sit in judgment on the arbitrator's decision if we're an annulment court. And if we're not, if it's a London-seated arbitration, it's not the business of an Indian court to say whether it's right or not. It's to let the tribunal go first and then let the supervisory court in England have that say. So I don't believe that these preliminary courts need to have a definitive law, but for something like an anti-arbitration injunction, they would need a definitive view. And a definitive view does not come from a theory of law. It comes from saying, no matter what law the arbitrator applies, this is not a valid arbitration agreement. So if I wanted to enter into an arbitration agreement with my wife about whether we are divorced or married, then the court could say, I don't care what law anyone applies. This is not an arbitral provision. This is not something you can take to arbitration. It's just not acceptable. So I can say this is an invalid agreement. Or if parties orally agreed to arbitrate in a seat that requires a writing requirement, a written arbitration agreement, then the court can say, no tribunal would uphold this, no annulment court would uphold this, therefore I can say there's an anti-arbitration injunction, stop wasting people's time. With an anti-suit injunction as applied in Enker and Sol America, the other thing that they did, I think wrongly, understandably though, is they used the common law principles for anti-suit injunctions developed for court cases. Now, why is that a problem? Because it makes it harder than necessary. An anti-suit injunction for court, when you look at the jurisprudence, says it's there to protect our court's jurisdiction. Well, you can't know that you can apply, you can grant one without deciding you have jurisdiction. And a merits court knows whether it does or not. It will hear all of the evidence that it needs to decide jurisdiction. And once it decides it has it, that's it. It's prepared to hear the case. And the second thing that they say is we award anti-suit injunctions to stop unconscionable conduct somewhere else. Now, all of these bad drafted cases, they're not unconscionable. They're debates about whether a non-signatory is included or whether your agreement was induced by fraud. So the criteria for anti-suit, I don't think should apply to arbitration. I think as a side issue, the normal balance of convenience test should apply. And you should simply say, is it more convenient to let the tribunal go first? Yes. Therefore, I will injunct you against continuing with that court case. Finally, people will get the wrong idea and make bad decisions if they presume, as the National Thermal Power Court did many decades ago, that once you have a law of the arbitration agreement, that answers everything. It should not answer formal validity like in Sol America, because in Sol America, I would have simply said, this is the one where it's a clear London-seated arbitration, but the choice of substantive law is Brazilian law. I would have said, if Brazilian law says you need a new arbitration agreement, that can only be for arbitrations in Brazil. We're not an arbitration in Brazil, we're an arbitration in London. I don't need to know anything about Brazilian arbitration law because it does not apply. The second thing I would have said, don't come into my court and tell me that it might be a problem. The burden is on you to show that it's a problem and give me the evidence as to Brazilian law. I did the research and Brazilian law doesn't say that. The whole of Sol America was based on an erroneous premise of what the law of Brazil was. And as you know, under Indian private international law, and other common law, if you don't have proof of foreign law, it's presumed to be the same as your home law. So if the party who said, oh, there might be a problem in Brazil had no evidence, they should lose either because they got the burden, or they should lose because of the presumption that Brazil law was the same as English law. So there was absolutely no need to decide Sul America on law of an arbitration agreement if you said rightly that your procedural issues are governed by the seat. Your substantive law issues, Brazilian contract law, are under Brazilian contract law. But Brazilian arbitration law has nothing to do with a seat in London. And just very quickly, one or two others. Capacity, if you're arguing that a government instrumentality cannot enter into a contract with an arbitration clause, well, the New York Convention has a special rule on capacity. It doesn't say it very clearly, but it says the capacity law applicable to them. And most people say an individual is your nationality, a corporation is where it's registered. So you don't need anchor case to tell you, get the law of the agreement, and that will tell you capacity of companies, no matter where they come from, anywhere in the world. That's not what people will do. Forgery. If you're arguing that the contract was, my signature was forged, do you really want a different law for the arbitration agreement and the rest of the contract? No, you're going to decide one way or another, what's my evidence of forgery, and I'm going to decide on balance whether it is. And the final one is non-signatories, and I won't repeat what I said before. When you're dealing with that, you should do, every country should do what the Indian Supreme Court has done, which is to develop a theory directed at the right way to deal with non-signatories, and not try and deal with it technically simply by reason of finding a law applicable to the arbitration agreement. So let me finish by simply saying that I definitely agree from where I sit outside India. I've been to India and enjoyed it immensely, but right at the moment I'm outside of India. Where I sit, I can certainly see tremendous work by the courts, a huge number of brilliant young and not so young sometimes lawyers interested in arbitration. When I teach at Singapore, a lot of my class are Indian students, and they're spectacular students, and I see them go working everywhere around the place. But there will be some gateway moments when some of the arguments will be raised by one of the parties before the courts that will eventually go up to the Supreme Court, that will eventually require a fuller bench, that could slow things down and hold things up and make it inappropriate. But otherwise, I do agree with the introduction that said one should look to build arbitration in India. One should have the seat of arbitration in India. One should have the physical facilities there. And I hope to see each and every one of you in an arbitration in India at some point in the future. So thank you again for the kind invitation, and I'd be delighted to take whatever questions people wish to throw at me.
Thank you so much, Professor Waincymer. What a delight it was to hear your views, and you coming from a different approach, asking about right questions and who should ask those questions at what stage. I think this is what we need to keep in mind. We have a question in the chat box. Chiago, my dear friend from Brazil, he writes, considering the jurisdiction of ICSID and other investment arbitration procedures, I'd like to know what would be your point of view about the applicable law on investor-state disputes and the so-called jurisprudence constant.
Okay, so investor state is slightly different to what I've been talking about. Certainly, all of the leading cases that I was discussing were dealing with commercial arbitration, not investor-state arbitration. When it comes to investor-state arbitration, you've got two kinds of investor-state arbitration. You've got contract-based arbitration and you've got treaty-based arbitration. And the vast majority of investor-state disputes do not raise this issue about the law of the contract or the law of the seat, because they're not based on contract, they're based on a bilateral investment treaty coupled with the ICSID convention. So the government makes a promise in its investment treaty that any investor from the other country will get protection and will be allowed to take the state to ICSID, and ICSID doesn't have a seat. So it doesn't use the seat mechanism there. So for those kinds of disputes, the issues that I've discussed today do not apply. Furthermore, you don't have the national courts dealing with the issues in the same way. You don't need a national court to appoint an arbitrator in an ICSID dispute. So it's only if you've got a contract as well, which does often happen. So you will have a commercial, let's say the government puts out a tender for a major construction work and a foreign engineering company or construction company wins the tender, and that contract may itself have arbitration provisions. And then you have extremely messy situations where you will sometimes have an investor-state dispute going on here and a separate contract dispute over here. And that can also arise because of the very broad definition of investor. So because an investor can be the actual company that invested, but also a shareholder in the company, then you have had cases where the company itself brings a claim in one forum, the shareholder brings virtually the identical claim in another forum, and the decisions conflict. So that can be a mess in itself. All I would say about investor-state disputes as well, once again, there is no right answer to bad drafting. And so many of the investor-state jurisprudence constant, which I was asked about, to me is inappropriate attempts to have a strict set of rules built on bad drafting. Let me just give you one example. If your bilateral investment treaty says this treaty comes into force on the 1st of January 2023 and it protects investors, that's bad drafting, because it doesn't tell you whether on the 1st of January it only protects new investors after the 1st of January, or whether on the 1st of January it retrospectively gives protection to investors who were already investors a year before. And there is a whole set of cases that try and come up with a theory of what should apply when it's just bad drafting. If you drafted it clearly, there would be no dispute. And if you've drafted it badly, there can be no theory. There's no theory of international law. It's just, what did your government mean by that promise? So in that scenario, you are interpreting the treaty. If you are interpreting the treaty, you are using things like the Vienna Convention on the Law of Treaties, and that allows you to look at purpose as well as plain meaning. That allows you to look at the travaux préparatoires, the negotiating history. And again, you wouldn't be making this final decision at a preliminary court application. You'd be looking into all of the history to decide what was intended and why. And I remember being involved in an investor-state dispute once about this particular issue. And you had a country which I won't name but where a very, very revolutionary new government replaced a very, very old-fashioned monarchy. And the debate came up about, and they entered it, the revolutionary government entered into a bilateral investment treaty, and it didn't say clearly whether it only covered new investments or old. And everyone was going through all of these cases. And I just looked at them and said, do you think this revolutionary leader wanted to protect all of the investments that he said were corrupt made by the previous monarch? I don't think that is likely to have been the intent in that particular commercial environment. Now, it may be right, it may be wrong, but I was simply saying you don't find case law to deal with this issue. You go and look at what seems sensible in those circumstances. And I keep coming back to it. It's exactly what the Supreme Court of India said in Enacon. Just look at what really happened and make a sensible decision in hindsight as to what you think the true intent of the parties was at the time of negotiating the agreement.
Thank you so much, sir, for that response. We have a question from Shruti. She asked, in practice, in your experience, what is the opinion of the parties to an arbitration? Do parties prefer a commercial approach, where the test is that of a commercially minded business person, or do they prefer a technical approach where the applicable law is sought to be determined? The latter has the potential to elongate the dispute resolution process, defeating the efficiency.
Okay, thank you for the very good question. I'll answer it in this way. There isn't one answer to that question, and it depends on who is in the room. I think if you had no lawyers in the room and you only had the business people in the room and they actually had a real issue in dispute, I'm not thinking about respondents who really know they should pay the money and are just trying to drag it out and be difficult, but people who have a real dispute. Business people see a legal dispute as a business problem. It's just money. It's just the business. It might be money, it might be who owns the patent, whatever, but I deal with business problems every day, and a legal fight is a business problem, and I want the best outcome at the lowest cost. And I don't just want a static outcome, because it might be a fight with my joint venturer, and I want them to still love me, and I want to still work with them, and I want to still make money in the future, but there's too much money to give away. We're having a fight now, we need it resolved. So commercial people generally want commercially minded arbitrators who are efficient, who are cost effective, who think about the facts and the numbers and the money and the commerciality, who can look at a balance sheet, who can do discounted cash flow when you're doing a damages assessment, who can really understand from the business point of view, what's this business problem worth and how should it be resolved? When you bring lawyers into the room, they vary. Some lawyers are very commercially minded. Some lawyers are very precedent, what's the law minded. And my view about the better lawyer is the lawyer who turns to her or his client and says, what do you want? What do you want me to do? Do you want a legal fight with technicalities, or do you want a quick commercial dispute resolution? Because if a client comes to me and says, I want you to sue someone, I say, no, you don't. You don't want me to sue someone. You want a commercial outcome. You want something. You think that suing someone is the way to get you what you want. It may well be. You tell me what you want. Oh, I want money from that person because they built a building and it was broken and I had to pay that money to fix it. I want money from that person. Okay, now I know what you want. Now let's talk about the different ways of going about it. You could negotiate, you could mediate, you could do a new deal where you're offering them something in return, or you could litigate, or you could go to arbitration. There's the mechanisms to get you what you want. Now, if sometimes a dispute can only be resolved with a detailed legal analysis. Sometimes the only issue is a question of law, but that's in 5% of my life experience. The vast majority of cases are fact dependent. And because facts are uncertain and they're disputed, then business people know it's dangerous to have a winner-take-all expensive legal exercise. The biggest arbitration ever, the UCOS case, had $60 million in legal fees for one side. 60. Now, some people are happy for that, but most people, this is not a good thing. And again, when you say how should it be conducted, and I think you also talked about common law pleadings and civil law pleadings, there's a huge difference between old-fashioned common law discovery, where some legal firms might be charging $1 million a month just for associates and interns grinding through documents. And other times an arbitrator might say, I'm not going to allow you to do that. I really want you to tell me what are the core documents that really matter so that we can, I only want you to give me a document that you really are going to rely on. Don't give me anything to read that you're not going to take me to in your submissions. I will read lots of things. I'll read as much as I need to read, and I'll read it carefully and I'll synthesize it. But why give me 20 lever arch folders of things you do not intend to make submissions about? So again, it is all about the efficiency, and arbitration is a commercial service. If I am privileged to be invited to be an arbitrator, I am a private person that someone wants to resolve their dispute rather than them go to court. And the fundamental principle of arbitration is it's consent-based, and I am bound by an agreement of the parties. So the real answer to that question, which I should have started with, is I will do what the parties want. If the parties want technical common law pleadings, which I hate, I do not like them, I will accept it. I'll try and talk you out of it, because I'll say, you know how annoying it is to say, do not admit, deny, do not admit this, plaintiff is put to his proof, whatever. And I'm trying to work out, how do I run this arbitration? What are you really fighting about? I'd much rather people actually say, I agree with this, I don't agree with this. The reason why I don't agree with this is et cetera, et cetera. And those of you who do work in the field know that we're becoming a hybrid. It's not about common law versus civil law. It's really trying to marry the best features of each legal system. And again, to do that in the way the parties want, because that's what they've asked for. If they would like a Zoom arbitration, I will do that. If they'd like the hearings in India, I will do that. If they would like the hearings in Singapore, I will do that. If they would like a 2-week hearing, I will do that. If they want a 1-day hearing, I will do that. And that's very different to the courts. When you walk into the courts and you are dependent on court procedures, on court timing and whatever. And the one thing you can't do in court is jump the queue, unless you can make an application for an emergency. But with arbitration, if you can find an arbitrator ready to hear your case tomorrow, you can start your case tomorrow. So again, everything is about consent, and those who are interested in working in the field and aren't yet doing it, that's the mindset I invite you to do. For the younger people listening, to really be commercially focused. And the best arbitrators do understand the numbers, because the numbers matter. And too many arbitrators spend a lot of time on liability and nothing on damages. And they don't understand damages, so they read the 2 expert reports, they listen to them being cross-examined, They don't understand most of what they're listening to, and they say, "Oh, he sounded more convincing than her," which can often be misogynist. Male arbitrators preferring male voices to female voices, which is a problem. But generally speaking, what you need to do as an arbitrator is be honest about what you know and what you don't know, and say, I understand that the assumptions and the discount factors are going to be crucial to the lost profits claim. Can you please explain why your assumption is different to the other experts? What's your reason? What of her reasoning do you agree with? What do you not agree with? Why don't you agree with it? And most importantly, you two are leading experts on damages assessment. I am not. How do you want me to decide between the two of you? What's the logic that you're going to give me to allow me to honorably, in a way that everyone respects, decide between these two expert witnesses? So again, the more commercially minded people are, I think the further you will go, particularly as India comes out of the court skirmish stage, where there still are, for understandable reasons, too many court applications about, oh, we held a hearing in Delhi, not Mumbai. Did we change the seat, or is that a seat or a venue, or this, that, and the other? So there are a lot of incentives to make applications. If people are doing that just to delay their client having to pay, that's fine. That's what you're entitled to do as a counsel. If you're doing it because you think it's a really good idea, I'd ask your client if they want to be spending all of that money rather than focusing it on the commercial dispute at hand.
Thank you so much, sir, for your response. It is 1:18 p.m. here in India. Would you like to take another question, or is it?
I'm happy to take as many questions as people would like to throw.
Sure, because as you mentioned, consent is the real basis.
Indeed.
This is a question from me. In the presentation, you mentioned there are few things about which everybody agrees. One of them is the express intention of the parties, and then you also added implied intention. But isn't it the implied intention, determining it, is the crux of the entire issue? Because then it is the court's interpretative task, how they are implying the intention of the parties, and then that results into, they formulating various rules at the preliminary stage or at the annulment stage, whatever stage it is.
I certainly agree with that description, and essentially I disagree completely with the way the courts are discerning implied intent. And all I said was agreed was that if you really did have sufficient evidence of implied intent, then implied agreement is as good as express agreement. So if you know for sure that people impliedly agreed, then that's good enough. Now the facts there's no simple fact that I can think of off the top of my head where that would be so. As we all know, in your domestic contract law, you can't imply terms into a contract unless they're necessary to give business efficacy to the particular agreement. So you could never imply a choice of law for the arbitration clause on that basis. You don't need to, because if you're in Mumbai, the tribunal's got a discretion to pick whatever law they think is applicable. So you don't need the Supreme Court of England to tell you what the one law must be on an implied basis. And for me, I would rarely be able to find implied intent just on the face of the documents, as the English courts have sought to do, and the Singapore courts and the Hong Kong courts. The only way I would find implied agreement is through contemporaneous evidence. For example, you could have people in the negotiations saying, I want to have the contract for 5 years. And the other one says, I want 4. And the first person says, okay, but only if we have arbitration in India. And the other person doesn't say a full arbitration in India. I want everything in India. And the other one says, okay. We don't have a clear agreement that Indian law applies to the arbitration clause. We've only got that, but I might say, look, this was a negotiation. You really wanted a 5-year term. The other one said, well, if you're going to give me that, I really want everything that could relate to India. We didn't go into the detail. That was either an express agreement or it was an implied understanding. A reasonable person in your position would have taken me to mean that, and therefore I should allow it on that particular basis. But I agree with your proposition. It becomes really problematic when a preliminary court with no evidence other than affidavit evidence, which contradicts each other, because one is saying that there's no real arbitration clause and one is saying that there is, can somehow find implied intent. I don't think that's the way to go. And again, that's not what the Supreme Court in Enacon did, which is to look at this way. And the other thing I should say in relation to that, which many of you would know of, and it's come up recently in the Kebabji case where the French court and the English court have differed. The French approach is not to look for a law of the arbitration agreement. The French approach is only to do what the Enacon court said. I'm not interested in an applicable law. I just want to look at all of the evidence. What do I think the parties really did here? Did they really agree to a valid arbitration, or they didn't? Did they really agree that the scope would cover torts claims as well as contract claims, or they didn't? And in the Enca case, they were just a French arbitrator or court would just look at the negotiating history and say, did you really want anything in a Moscow court? For those who don't know, that the Enca case goes to 3 levels of an English court, goes all the way up to the English Supreme Court. In the meantime, the Moscow court was asked to send it away. It would not. But the party that did not want to go to Moscow, only wanted to go to arbitration, won the case in Moscow. So you had 3 English cases and a Russian case fighting about what's the law of the arbitration agreement. And I don't know how much legal expenses all around for a ruling on law that wasn't useful in the end anyway, because the party who didn't want to be in Moscow won in Moscow and was then happy. So really, the courts should do what the Indian court in Vidyadrolya said: get it to an arbitrator as quickly as you can. Don't let's keep fighting suit injunction or not. It's going ahead in Moscow anyway. The anti-suit injunction was ignored, so it's not being helpful. Let an arbitrator decide if that's what you wish to do. Now, in some cases, there won't be an arbitrator deciding, because in Enca didn't want to go to arbitration because they were the defendant. They didn't want to go anywhere. They were just saying, I don't want to go to arbitration, but if you want to sue me, that's the only place you can go. And Chubb that wanted to sue them said, I don't want to go to arbitration. I want to go to a Moscow court.
Right. So you mentioned about Enacon and how co-decession in Paris takes a similar view, but co-decession also mentioned that, okay, let's identify common intention, common applicable law, but that is subject to transnational public policy, whereas in India, it would be subject to Indian public policy. Do you think that would still make a French position a better position? And adding to this, Swiss approach, wherein in their legislation itself they said, as far as applicable law of arbitration agreement is concerned, we are fine with any law.
Well, three laws, not any, but three. Yeah, they got three.
It should be valid under any law.
Yeah.
Choose any law, and we are fine with that. So, do you think these are also good approaches?
Okay, so my central argument is only against the court
Correct.
logic of needing a law of an arbitration agreement, deciding itself what that is, and making that answer everything. In terms of your first point, the whole idea of the New York Convention was that even if you are promising to respect foreign arbitration awards and arbitration agreements, if your public policy says you don't want to, that's fine. We can't get people to agree, as you know from your question. It only talks about domestic public policy, but people say it's transnational, but some countries will apply their own, some countries will not. That's a separate issue. I have no problem with a court that accepts my thesis, defers to an arbitrator, lets the arbitrator decide, and then considers public policy. Because you will only consider public policy if someone asks you to, and 80% of awards are paid without a challenge. And even if someone asks you to block enforcement, it's discretionary, so you could allow enforcement in any event. But if you are in a country and you are a preliminary judge and you know that the only assets are in your country, and you know for sure you would not uphold this on public policy grounds, yes, I would allow you to say, forget it, no arbitration. But if you want to do that, offer due process to everybody, let them have a full hearing, let them argue, tell them that you're concerned about that. You don't want to waste time and money on a case which, whatever is decided, you may decide is not valid on public policy. If that defendant has assets anywhere else, I would want that judge to back away, because I would want the counsel to say to the judge, I don't need you to enforce. I can enforce in other places. And there are even commercial instances where people seek to enforce in a country where there are no assets for good commercial reasons. Why? Because the party might establish a business in that country, in which case you could enforce. So you can stop a competitor from starting a competing business in a jurisdiction with an award that is respected in that particular jurisdiction. So I have no problem. I have no problem with differing views. And your second part of your question was about the Swiss validation approach. That is a action by the government that we want to be so pro-arbitration that we want to find valid arbitration agreements more than any other country in the world, and Portugal and others, I think, have followed suit with similar validation laws to Switzerland. And that doesn't change what I say. That is what matters. That is the Swiss Parliament doing effectively what I say, but maybe even not as going as far as me. Why? Because the Swiss law actually names 3 laws, and it says if it's valid under this law, or this law, it's okay. I say as a preliminary judge, if it's valid under any law that a reasonable tribunal could pick, then I will kick it out of my court and send it to the arbitrator to decide. The arbitrator might decide it's not valid. They might pick a law that makes it invalid. They might pick a law that I don't think they should be allowed to pick. So, but if it could be valid to an arbitrator, allow it to go ahead, which is essentially what the Swiss Parliament tried to do with their provision, which I say every country should do unless they're told the opposite. 2 countries are an exception. One is Germany, where the government decided, rather than do the route where you go to an arbitrator first and then you review it in a court, why not start with the court that's the supervisory court? So Germany allows all challenges of validity and scope to go to the supervisory court, which is fine. Whichever way you go, it's not ideal. It wouldn't be good in a country with a big backlog, because you would just kill your arbitration practice. But Germany's quite efficient court system. They would have separate arbitral judges that can deal with things quickly. They wanted to do that. The second exception is America, because in America, they have the leading cases of First Options and Kaplan and the AT&T case. And American jurisprudence says, if you want an arbitrator and not the court to decide validity issues, you've got to be very clear. So that's unlike India and Australia and England, where we want the arbitrator to go first. America says it's not about first or second, it's about who. We, the court, will be the ones you must come to unless your contract makes it clear that you want the arbitrator to go first. And if that's what you want, we will not look as carefully at what they've done, because you wanted that. If you really want that, we will only interfere if they've done a very bad job. But if you don't say you want them to go first, we will go first. So every jurisdiction is a bit different. And my comments have to be read in any jurisdiction consistent with what that government wants as the interrelationship between courts and arbitration. And as you all know better than me, you've had a Law Commission report in 2014, you've had changes of the legislation, you've had that commission say it's not all in favor of a tribunal, but it's not the old-fashioned too much court intervention. It's a balancing act, supporting of arbitration to make India a leading center of arbitration, to allow the Indian business community to arbitrate at home, like was suggested in the introduction, to not have to go overseas, to not have to use foreign lawyers. So that's certainly what India is aiming to do. And again, my recommendations are, in my view, wholly consistent with the aspirations of the Indian government about the balance that it wishes to strike.
Thank you. Thank you so much for your response, sir. So if you permit, should we now sign off?
Fine.
So it was a wonderful session, all of you. Thank you for your patience in this 1.5-hour session. I hope all of you benefited from the experience and the suggestions given by Professor Waincymer. He made a very clear and coherent argument that it is, again, in my language, I might be a bit straightforward in my summarization, that it's not court's business to look into what the arbitration agreement law is. It is for an arbitral tribunal to do. Let them find whatever they feel appropriate. So to begin with the Sulmerica Court, Anchorage Court, the approach, the kind of questions they asked were wrong, and they ought to ask a right question. And we in India can learn from this. And what Professor Waincymer said, that's the kind of approach we can follow if we do not want to get into that trap of being in litigation for so many years and not getting any solution. At the end of the day, our dispute might not be resolved, for which we want to go to court or arbitration. What we are resolving is what the law is, and which can again at the end of the day remain confusing. So thank you so much, sir, for your valuable lessons. We really enjoyed it. More than 150 participants attended it. Towards the end, number has dipped, probably some other work commitment. Dr. Akhil Prasad apologized. Some other work came up in between. He passed his greetings as well. Thank you so much, sir, on behalf of entire university and journal board. We really appreciate.
Thank you very much. It was an absolute pleasure. And if anyone has other questions they want to send me by email, they should feel free.
Definitely, sir. Definitely. Sure, sir.
Thank you all.